right, good evening, everyone. Welcome to tonight's webinar. My name's Adam, and I'll be your moderator. We're joined by Mitch from Cirrus Consulting Group. Mitch will be identifying the $100,000 traps hidden in your dental office lease. If anyone does have questions during the webinar, please feel free to drop them in the Q&A or chat, and we'll answer them at the end. Henry Schein is not offering CE credit for viewing or attending this presentation, live or on demand. And this webinar is sponsored by Henry Schein's Dental Business Institute, as well as Cirrus Consulting. So with that, I will turn it over to Mitch.
Great. Yeah. Thank you very much, Adam. I appreciate the warm welcome there. And welcome. I hope that everyone's buckled up and ready to enjoy a nice presentation on the very riveting topic of dental office leasing. And nonetheless, actually a serious topic as well, as we will uncover some of the up to $100,000 traps that could be hidden within your dental office lease agreement. It's all very applicable information to whether or not you're leasing space in a medical office setting, traditional office setting, or perhaps a retail setting for your practice. Again, applicable for those of you who perhaps are considering leasing new office space for your first practice, perhaps a second location. If you're going through a lease renewal and negotiating terms with your landlord, if you're perhaps looking at expanding your office space or selling your practice. And those 4 times throughout your career really identify a very unique position of leverage that you as the dental tenant have. And for those of you who are landlords, we'll discuss some of the criteria to how to properly set up a lease agreement if you actually own your property as well. So with that, we do have some poll questions that we'll get to, and they'll pop up on screen. So if you have a moment, just please click to identify what most applies to yourself in your current situation. It just helps us better tailor some of the marketing material and the presentation material to you and the applicable situation that you might be in today for our course in the near future and the far future. But very happy to be leading tonight's course. As you'll see on the screen, that's my contact information. So if anyone has any questions, don't hesitate to email our info at email address. And I'm happy to say I'm a senior consultant with Cirrus Consulting. I've been with the group, with the company since 2014, and I actively work with clients across both Canada and the US. Review really the purpose of today's webinar. So just again, in the next few seconds, if you could just fill out those poll questions, I believe there's 4 or 5, and then just follow along and listen to really what's going to outline the next 45 to 55 minutes of the presentation material. But really the purpose of today's webinar is to outline those potentially $100,000 traps that could lie within your commercial office lease agreement. Again, very applicable to whether or not your position of looking to lease new office space, or if you have already signed a lease agreement. If you have a copy of that lease with you, perhaps follow along and identify some of the provisions that we'll review tonight. If you've unfortunately agreed to some of those, but we'll review a few of what those provisions may be through a couple of case examples. And then just make you better aware. I don't think many people understand the nuances or the gravity of a commercial office lease. I don't think that there is an elective course throughout dental school that discusses this material. So very important information indeed. And we'll provide a bit of a national kind of leasing market update. We spend a lot of money to subscribe to proprietary data that is offered to us in the efforts of being able to negotiate commercial office leases on behalf of clients throughout the country. And that information is a very useful tool, not just to actively represent clients, but to also really get a gauge on the market and see what's happening locally for clients that could be in the Southeast, the Northwest, all throughout the country. And there's some really interesting things that are not just happening now, but have happened as a fallout of COVID. Obviously, last year was a very wild year for commercial real estate. And all of you practice owners, if you have office space, you're in commercial real estate, whether you know it or not, because your leasing rates for retail space, medical office space, they've all been affected. And there's some interesting differences in the market as we'll look at Texas, we'll look at California, we'll look at Florida, and just provide some very tangible examples as to what's gone on through some of our vacancy and rental rate large sample size statistic updates. We'll discuss the ability for those of you who are leasing space today to be able to mitigate risk and control that exposure to liability through some tactics in negotiating your lease. So just really kind of like a treatment plan. We'll discuss really some options that you have kind of on your tool belt, more or less, to be able to negotiate with your landlord and just be sure that you're not overly exposed with your landlord. You want to be sure that you're limiting any kind of undue liability or risk when you're dealing with your landlord. And then we'll also just look at some of the common mistakes, unfortunately, some practice owners make when leasing office space. I think a lot of people, they really just sign a lease agreement and they don't know the gravity of what that potentially 50 to 100-page document poses to them personally or their practice. So we'll look at a few examples through that as well. For those of you who are not familiar with us, our firm was founded by dentists for dentists. We've been in business now for over 27 years, and we actively represent practice owners across Canada, the US, and we've taken on files in both the UK and Australia. We, at the heart of it, are a tenant representation firm, although we do work with the odd landlord and actively represent them. Essentially, what we do is we have a very hyper specialized service, and we negotiate the terms, both the financial and business terms of the dental office lease. So a very, very hyper niche specific service indeed, but nonetheless, our years are nearly 3 decades of intellectual capital and just experience in the market has proven to give us a very valuable service that's offered to practice owners across, again, the continent. And it's very important because not many business owners that are going to be entering into office space or retail space invest such a large sum of money into space that they don't even own. So it is quite unique, and that's really birthed the value to our service. We lecture typically at live seminars across the country, so you might recognize the Cirrus brand at courses or conferences like the Yankee Dental Conference, the Pacific Dental Conference, the Hinman Dental. So you may be familiar with, maybe not myself, but a colleague, if not the brand, as we work with clients across both Canada and the US. We'll lecture typically at live seminars at over 100 CE presentations throughout the year. Since 2020, a lot of those presentations have been turned to virtual courses like the one I'm delivering today. Most of these presentations are CE accredited, although not tonight, and we're very grateful to be sponsored by Schein and delivering this course in conjunction with them. The services that Schein offers and promotes are very, very valuable. But having said that, we'll just look at kind of the disclaimer moving forward. So the following slides contained and the forward-looking statements, including the statements regarding trends in the real estate market, prices and vacancies. These forward-looking statements are not guarantees or predictions or future performance and involve known and unknown risks, uncertainties, and other factors, many of which are beyond our control, and many of which may cause actual results to differ materially from those expressed in the statements contained in this piece. Viewers are cautioned not to put undue reliance on the forward-looking statements. So really all that this disclaimer is referencing, or prefacing rather, is that we have some really good information to historical data in the commercial real estate market. And this data really helps a lot of potential investors or practice owners make decisions on where is potentially best to open up a new practice. Where are the good, attractive rental rates right now, and what's trending upwards by way of increased construction or population activity, as to where, potentially might be best to open up a new practice. But having said that, as we all saw last year, COVID was very unforeseen a very unforeseen event in the marketplace. So no statistician or economist was able to predict that event. So having said that, a lot of the stats that we'll present today, the updates in the market, they're nothing to bet on. It's just very good information that we have. So for example, the market update, the first slide that I'd like to go through really references two things. It's the national market growth rate as well as the national availability rate. And you can see, this is over the course of 5 years, both slides, that there was a huge swing, a huge change in the year of 2020. And first, looking on the slide or the graph that should be on the left of your screen, that we saw growth rate in commercial real estate activity decline massively in 2020. Not to belabor the facts, but essentially a lot of business owners that were occupying office space or retail space either resorted to working from home, or the businesses that could simply utilize e-commerce solutions took advantage of that and did not need to lease office space. And that created a huge difference in this massive industry that you're all a part of, and that's commercial real estate. And then second to that, the national availability rate, obviously the effects of supply and demand. We saw the big difference in, obviously, with a large amount of vacancy. The opposite effect of that, the big availability rate shot up. And that obviously will be affected with essentially a rental rate that will decline. So it's kind of been a very wild year for commercial real estate. I'm not sure it's the best, topic to discuss at a dinner party. Not many people would find it so entertaining, but we go through this and we deal with this every day. So we find it quite interesting. The national leasing activity year over year, you can see declined very heavily. This is a very large sample size. It's looking at all of the United States. Canada is not included in this particular graph. But essentially on the left, you can see the leased square footage in the hundreds of millions declined rapidly in 2020. And that's just because businesses unfortunately went out of business and no longer had the use of renting office space, or they decided to work from home. You'll all be very familiar with the fact that you have a brick and mortar business. And the last time I checked, dentists are not making house calls. You're going to need that real estate. You have a very unique business type in that your business, even in rented office space, is very much tied to the real estate. So despite a pandemic, despite e-commerce solutions, you're always going to need 4 walls and a door to welcome in patients. No virus, no Amazon is going to change that. I can't fully predict what the future holds, but we saw all of the crazy changes that happened last year, and with all of those retail and office businesses that had to undergo that change, certainly dentistry is something that has withstood the test of time. So now more specifically, for those of you in the Southeast, in Tennessee or in Florida, looking at, again, office, medical office, and retail, again, a very big sample size. Just the specific statistics for space, the vacancy rate and the market rent rate per square foot, we can see that this year right now, the average rental rate is close to the $30 to $32 per square foot. We can see the forecast, again, a forecast, not a factual number, but a forecast, is that the vacancy rate is going to be trending downward. So we're seeing an uptick in the value of rent, right? There's always that opposite effect, the supply and demand factors. And then in Florida, Orlando, Florida specifically, we have a bit lesser of a value for the rent value per square foot. And you can see both the intersecting lines closer to 2020, where the vacancy went up and the rent rates went down. And that was just to attract more use. There was more inventory on the market. So the landlords, the property owners were really just trying to attract more tenants, more customers to their space. Looking at North Carolina and Georgia, very similar. Both Charlotte and Atlanta didn't hold as valuable a rent dollar per square foot as Tennessee. And I believe that's just because primarily in Georgia and North Carolina and a lot of parts of Florida, more real estate is privately owned, just families or single to 2 or 3 property owning portfolios. It's not a lot of large institutional owners like you see in downtown Nashville. So having said that, you have the lower kind of per square foot rent value, and then all predictions point towards a higher increasing rent value per square foot. Moving to Texas in the Midwest. Texas wildly last year kind of had and held a stronger rent value per square foot, not just in Houston, but across from Austin, Dallas. And I think that was due to the fact that a lot of business owners and a lot of people had migrated from California to Texas. There's a big increase in that local economy for the state. So the rates there had been the best that they've been in years. But nonetheless, you can see there the rates and the vacancy statistics for Chicago and for Houston. New York and Boston, a lot of really, really dramatic cases came out of New York last year, especially for clients of ours that were in Manhattan. People obviously were very worried and trying to exit the city, kind of not sure of what the future held. New York will always be New York, but I know last year we got a lot of calls from practice owners looking for any potential way to exit their lease agreements and really leave the city. There's a death and disability clause, essentially an exit strategy that you can build into your lease agreement. And if there's any kind of injury that you or your spouse come to suffer from, that it can give you the ability essentially to exit the lease agreement. And a lot of our clients were exercising that right to exit the state last year for those that had moved out of the city. So I think with that clause in a commercial or retail office lease agreement, we'd probably help contribute to more than 100,000 square feet of office space or retail space that was now all of a sudden vacant in the city. Phoenix and Los Angeles, you'll see as well. LA still always a very kind of strong rent value per square foot. A lot of differences throughout that city, but nonetheless, you can see the trends for all the cities that we've shown on the screen is trending upward. So very valuable space nonetheless. And moving on just from those statistics, again, they're not predictions. It's just it's a collection of data translated to a graph. So very valuable information in the present term, but not necessarily in the future term. You shouldn't make bets on that information. Typically at a live seminar, I like to ask this question for the audience, and it's really just to kind of take a step backward and ask yourself, what is a lease agreement? With all the commercial real estate talk, with all the the buzz terms of vacancy and e-commerce and all that, I think it's important just to take a pause and ask ourselves, wait, what is a lease agreement? So right now, if I can ask everyone who's attending tonight's course, just to take a pause to ask yourself, wait, what is a lease agreement? And with that being said, essentially the lease agreement is a big order of money, right? If you're looking at signing a new commercial office lease, if you're looking at opening a new practice and the landlord has thrown down a package of paper in front of you, probably on the first or the second page, there's a rent schedule there, and it's outlining a commitment for you as the tenant to pay month over month an amount of money, a sum of money to the property owner. And that money over time is going to add up to a very large sum. For some of you, it might be the most expensive agreement that you ever sign. So it is a very serious topic. As me, a member of Cirrus, I'm pun intended, happy to kind of give you that reality check. But no, beyond the first or the second page, where beyond that rent schedule is outlined, there's a lot of business terms that are identified as well. And if you've signed a 50 or 100-page lease, you really need to take the time to read beyond those first 1 or 2 pages. Because if there's a very large rent commitment and financial commitment from you as the tenant, beyond that, there could potentially be even a larger commitment in the business terms, the risks, the potentially $100,000 traps that might lie within your lease. So it's just important that we need to understand, what is the lease? What is the thing that we've signed to? If we're opening new space, if we have a renewal coming up, is there anything that we as the tenants can do to protect ourselves? And if you're a landlord, if you're on the call today and you own your property, please just take a second to realize, if your broker, signed that deal for you, on behalf of you as a landlord for the tenant, really understand what are in these kind of state outlined commercial real estate template agreements. What have I made my tenant sign? So today we'll review really the 7 financial negotiations or negotiables within your lease. First, looking at that base rent commitment. Second, the annual increases. Third, the common area maintenance charges. Fourth, the fixturing period. Fifth, the free rent period. Sixth, the tenant improvement allowance. Seventh, the landlord work. So I'd say 90% of commercial office tenants, they all sign that triple net lease. So a triple net lease is when you have your base rent commitment, and then on top of that, you have all of your triple net charges, your taxes, your maintenance, your insurance costs, and they all make the sum of rent that is owed to the landlord on top of the base rent charge. So it's really important that you realize, beyond your base rent, what are you paying for? If you're paying for, common area maintenance charges, are you receiving the maintenance that's due and owed to the building that really you're paying for? So you've got to understand, what is the landlord supposed to be paying for? If there's a major investment, a capital improvement due on the building, if there's maintenance needed for the parking area, if they're repaving the parking lot or replacing the roof, are you going to have to help pay for that because it's included in your common area maintenance? Yes, most tenants do have to help pay for that because it is included in the triple net lease design. So let's really just understand, are we on a gross lease? Are we on a triple net lease? What is it that we've agreed to? There's a few critical clauses beyond the financial component. So I think, just again, to take a step back and realize what it is that I've signed to. The commercial lease can be broken into 2 main categories, right? Your financial commitments, and then as well your business terms and those legal commitments that if you've signed personally or if your business has signed, those items that you've agreed to. So one, potentially the relocation clause. The relocation agreement basically outlines, and it's very common in a medical office building and a shopping retail center lease agreement, that the tenant, at any notice, could be required to be relocated by the landlord. So if the landlord receives a more competitive offer from a tenant that they would prefer to put at the end cap unit or in the space directly adjacent to the grocer, that the landlord maintains the right to move the dental tenant, yourself, to a different unit. This typically would not be such a big problem if your business wasn't so heavily reliant on those capital improvements, right? If you had an accounting office or a law office or a toy store, and really all that you had to put up were shelves and desks and computers, if you received a relocation notice from the landlord, it would not be as big a deal to have to pack up your things and move to a new unit. That's just the cold hard facts, the reality of it. But given that you have a very heavy investment in the plumbing, the electrical, just the unique floor plan of the way that your office space is designed, where your patients come in, they'll sit in the reception area. Hopefully it's very nice and you've got some entertainment there, and then be repositioned to an operatory, and there's plumbing lines that connects, just the chair and everything. It's a very, very unique type of space that a dentist operates in. And if you were to receive a relocation notice, it would be really frustrating, more frustrating than if that accounting office were to receive it, because now you're not just having to move to space that might be larger in size or smaller in size, but you're moving to space that's perhaps not plumbed. It doesn't have that same drywall that the space that you're in today has. So a relocation clause can be a huge, huge problem. And I would say probably 1 every 2 weeks, we receive a call from a practice owner across the country who's received a relocation notice. And at that time, they would ask, what can I do in response to this kind of notice? And unfortunately, there's nothing that can be done unless you've effectively changed or negotiated the terms of your relocation notice, your lease, before the landlord tries to send it to you. Then there's nothing that can be done. So you need to be very aware as to whether or not you've agreed to that. And if you have now, then look at when your renewal period is. Perhaps you can take advantage of that leverage that you've got and negotiate it out of the lease. We work with a lot of practice owners who are looking to acquire associates who are looking to acquire practices. If there's a practice that's got a lease agreement in place and there's a fair market rent rate and there's a relocation notice versus a practice that's got fair market rent rates and it does not have a relocation clause in it, well, the one without a relocation clause is simply going to be valued higher than the one with the relocation clause in it. And that's because there's a huge amount of liability associated with that. So if I were buying a business, a practice, I wouldn't want to commit to that kind of, that potential headache that I might have to deal with as a future practice owner. So just be aware of what you've agreed to. I've reviewed kind of the main summary as to, what that relocation provision could do to you as a practice owner or as someone who might be looking to acquire a new practice. But really some of the simple ways to protect yourself is to either A, negotiate it out of the lease, or B, to take advantage of some of the step down. So if the landlord is very, very unwilling to remove that provision from the lease agreement, well, great. Let's make sure that if we had to move the practice from unit A to unit B, C, D, who knows, that the landlord's responsible for paying for the relocation costs, that any kind of downtime that the practice suffers from, if you had to close those practice doors and you could not see patients, that the landlord's going to reimburse you for missed revenue that the practice would have missed when being closed. And if your space is going to be less desirable, if it's at a poor spot within the shopping center, or if it went from kind of ground floor of the medical office building up to the fifth floor, kind of facing the opposite end. We just need to make sure that there's those step down measures, there's those protective measures within the agreement. So we don't know what the future holds, but if we have those elements of protection, then no matter what happens, we'll be protected. So here's just a sample of the landlord's reference language. And this language was copy and pasted from an agreement that we had received from a client. And then all of the client's names and information was removed from the lease. So the landlord may at any time upon 60 days notice relocate the premises to premises reasonably comparable in size. The tenant will reopen for business to the public in the new premises by the date set out in landlord's notice of relocation. If the premises are relocated, the lease will remain unchanged except that the rent will be adjusted based on the gross leasable area of the new premises. The landlord will reimburse the tenant for any reasonable costs and expenses due directly to the relocation. The tenant may not claim against landlord for damages or indemnification or by reason of loss or interruption of business. The tenant will execute any documents required by landlord to give effect to this section. Notwithstanding the provisions hereof are to be construed broadly in favor of the landlord. If the tenant objects to the relocation, of the location of the premises, the landlord may elect to terminate the lease within 30 days written notice. So we, again, in summary, have reviewed many reasons as to why a relocation clause within a commercial office lease can be wildly problematic. But for example, just that final sentence there at the bottom of this example shows what kind of position it would put you in as a tenant. So if you received a notice from a landlord that you had to be moved to a new unit and you were objecting to that, the landlord could terminate the lease. Right? It's this control that these landlords, big institutional landlords and some small, mom and pop landlords that just hired a lawyer to draft their lease agreements will put their tenants into. So it affects a practice owner way more than a typical business owner, because when your business is appraised, any buyer that would see a relocation clause is going to think, oh my gosh, I don't want to have to be exposed to this kind of issue. I'm going to either A, walk away from the potential deal, or I'm going to B, submit a lower purchase price on the practice. And now you as the owner, you're out, right? You've lost potentially tens of thousands of dollars because of a stupid and very annoying provision in the lease. These are the issues that I've just italicized and highlighted for you, right? The difference in gross leasable area, the landlord's ability to terminate. The cost of the mistake, depending on the verbiage, could vary. The second provision that I wanted to review quickly, and I know I'm already eating up into a lot of our time here, but is the assignment provision. So again, for anyone who is looking to transition, if you're considering a retirement in the next 5, 10, 15 years, this provision is very applicable for you. It will affect a practice owner who leases their office space, because at some point when you're looking to sell your practice, you're going to have to transfer the lease agreement from yourself to the buyer. And the way that you would do that is through the assignment clause. So the typical definition of the assignment provision is essentially it allows tenant A to be able to transfer the lease from themselves to tenant B, subject to several conditions. So the issue with the way that many assignment provisions are outlined is the fact that the tenant would have to receive the landlord consent to be able to transfer the lease. If you can't receive that landlord consent, like their green light in the ability to transfer the lease, then what are you left with? Now, you've got this practice and it's been appraised for, X amount. And part of that value is predicated on the real estate. But if you simply can't transfer the lease, then the buyer, what are they going to buy? They're really only going to buy the value of the goodwill and the equipment. They're not going to be inheriting the real estate. So we need to be sure that the assignment provision is drafted in such a way that when you're looking to transfer the lease, you're merely providing the landlord with notice. And as long as the potential transferee, the person inheriting the lease, and having it transferred to them matches the criteria that you've pre-negotiated in the lease, then the landlord cannot get involved. The value of the leasehold improvements in the space, and if you've built your office space, you would know down to the cent how much money was invested into the property that is not yours. But all of that value, right? The potentially $250 per square foot in leasehold improvements that you invested in should ideally be resold to the buyer. If you're not able to do that, you've just lost all of that money and given it to the landlord. Because really, at the time of practice sale, when you're selling the practice as a whole, right? It's leasehold improvement value, it's patient charts, it's equipment. You should be reselling the leasehold improvement value. But if the landlord's not allowing you to transfer the lease, now you're not able to transfer those leasehold improvements. So ideally, if you're able to identify the assignment clause and negotiate it in the tenant's favor, in the practice owner's favor, it really should provide you with the ability to transfer the lease without dealing with the landlord's arbitrary control and them withholding their consent, without the landlord getting involved in claiming ownership of those leasehold improvements and potentially collecting a portion of the sale proceeds of the practice sale. And finally, for those of you who had to provide a personal guarantee, even if you transfer the lease and now someone else is in the office space and they're running the business, it does not mean that you've all of a sudden become free and clear of any liability, right? If you provided that guarantee and you transfer the lease, it still means that you're on the hook and you remain continuously liable, so that the new owner, if they can't run the business as effectively as you did, the landlord could come after you for missed payments of rent, defaults on the lease agreement, a whole host of things. So ideally, when you transfer the lease, you are done. You don't have to remain continuously liable, and you don't have to worry of, does this property owner have any kind of hooks in me? Do they have any kind of control? So that's really what you need to be cautious of, beyond the fact that the value of the leaseholds is tied up in the assignment and the landlord's control is there as well. So a very important provision. And if you're not aware of the page and the provision number in the lease agreement for where the assignment clause is, I suggest you get familiar, because this is one that we get calls on weekly, if not bi-weekly, from practice owners across the country. And there are building owners who, to their core, believe that the businesses in their building are only worth a certain amount because they are simply located in their property. And they will fight tooth and nail to try to claim the value of the leaseholds. So it's a very important one to be cautious of. So here's an example, right? We discussed reviewing some case studies, but here's one that we've copy and pasted from a lease agreement that we received from a client. Again, changed the names, redacted some information for privacy concerns, but just take a second now, see if you can identify a couple potential problems. And I already realized that we're running short on time, so I'm just going to show some of the issues. So again, first, as I mentioned, if there's any kind of landlord ability to arbitrarily withhold consent in the lease transfer, just at the tenant's request, we could have a problem. If you as the tenant request to transfer the lease agreement, we saw this in this particular example, we've seen it a number of times just in those state prompted commercial leases, but the tenant could have one of several options. They could either have the option to approve the tenant's request to assign the lease, to decline the tenant's request to assign the lease or sublet the premises, or 3, to terminate the lease agreement upon the effective date of such proposed lease assignment or sublet. So the hard question is, if you go and you ask your landlord, can I transfer the lease and sell the practice? And they say, no, I can't. You can't transfer your lease. What are you going to do? Right? Like, what would you do with your pending practice sale? Pending that, the landlord should have the right to revise the minimum rent to be paid during the remainder of the term to the greater of the then current market rent for the leased premises, 15% greater than the then current rent. So the problem with this is, if you're looking to transfer your lease, you found a buyer, you're about to sell your business, and the buyer is all excited, but now they receive a notice that your rent went from A to C. What's going to happen to the potential sale? Now, the buyer is going to be upset because they don't like the landlord and they don't like this updated expense that they're going to have to take on. So it can really muddy the waters for the sale. So we need to be cautious of that, because you as the seller really should be the one controlling the inherited expenses that this new practice owner is going to take over. Furthermore, should the tenant receive from the assignee or subtenant any rental income, cash goods, or any form of consideration in connection with the assignment of this lease or sublet of the premises that is over and above the current base rental rates payable to landlord in any fiscal year during the term of the lease, the difference between the annual rent rate and such rental income, cash goods, or other consideration shall be paid directly within 30 days of tenant's receipt thereof. So big problem here, right? If you're transferring your lease, you're only going to do that when you're selling your practice. You're going to receive a lot of money for the sale of your business. Tied to the sale of your business is the value of, again, the patient charts, the equipment, just the goodwill of the practice, marketing and the name, as well as the real estate, the location, and the leasehold improvements. If the landlord sees that you're receiving money, they can say, what are you receiving money for? And if it's for those leasehold improvements, there's a very real claim that they can make towards that amount of money. So let's just be cautious here. Also, if you have an associate, depending on how your practice is set up, if they're not an employee, if they're a contractor, if they're paying you rent to take over an operatory, if you have a specialist that comes to the practice once or twice a week, and they're paying you rent to occupy one of the operatories, if it's money over and above the amount of rent that you pay, the landlord will see that as profit that you're making on really their product. And that delta, the difference between the rent that you pay and the margin that the subtenant is paying you, that's their money that you're making, and they'll go after that. Furthermore, and I mentioned this earlier, but really, if the original tenant transfers the lease, that original tenant is still to remain continuously liable. So please, if there's one thing that you take away from this presentation that we're making here on a Wednesday night, just to check and see, are you continuously liable through your assignment provision? We even get calls from people who have sold their business, and they're getting calls from their landlords, and they're saying, you owe me rent. But the practice owner who would have then sold their business didn't realize that, yes, they still have to kind of upkeep with the responsibilities of the lease agreement. So just check and see what your assignment provision says. The cost of that mistake could be potentially up to the full value of your practice, right? If you can't transfer your lease, if you can't sell your practice, it could cost you the full value of your practice. And if your practice is going to sell for between 75% to 100% of your gross production, well, there you have it. It could cost you, depending on how much your practice is, a great deal of money. So let's just be cautious and well aware of what that is. Yes, the inability to sell the practice, having to absorb a significant increase in rent, the remaining liability as a guarantor beyond the practice sale, and paying the landlord a portion of your practice sale proceeds. The third provision and case sample that we're going to fire off right now, because we don't have much time, is the option to renew clause. So not many people would even anticipate that this kind of simple thing within the lease could really be a huge problem for you as a tenant when you're looking to sell the practice, when you're going through a lease renewal. But we'll get into the example now as to why that is. But the option to renew clause defined really is a lease provision that gives the commercial tenant the right to renew the lease agreement beyond the existing term or the current term that they have now. So for you as a practice owner, it should really give you the flexibility to continue occupying the space that you have today, essentially extend the life of the lease beyond the current term to a future term. More importantly, if you are looking to sell your practice, the one thing that you need to be able to be sure of is, can the buyer for my business get financed? Anyone who's going for financing is going to have to give the lender a copy of the lease. If the lease agreement for the potential business purchase, that acquisition, only has a few years left of term, they're not going to get the loan. right? Depending on what the financial status of that lendee, that borrower is, unless they have a tremendous amount of cash to their name, the lender is not going to give that borrower a lot of money up front. They don't get a lot of money up front, they're not going to be able to afford the practice. So if you're trying to sell your business and you only have a few years left of term left on the lease agreement, the buyer's simply not going to get financed and you've just lost your practice sale. So you need to be sure, do you have enough term and options to renew that could be transferred to a buyer, so that when they do go to the bank and they ask for money and the lender says, okay, great, how much potential term is on the lease agreement? If there's up to 10 years, the bank is going to have zero issue with giving them that money. So let's just be sure that options to renew are transferable, and that they don't just exist in the current tenant's name. So here we've got an example. Dr. Joe Black is a false doctor. We changed the name from this copy and pasted provision out of an existing lease that we had on file. So just take a quick second and review this provision and see if you can identify why this would be a problem. So you'll know right away that provided that Dr. Joe Black shall remain as the tenant, and if the tenant duly and has regularly paid its rent and has performed its covenants and obligations under this lease and has not been in default, then Dr. Joe Black could exercise the option to renew. If you ever see a capitalized term within any legal document, just like the lease agreement, it means that it's been prior defined. So Dr. Joe Black, not just because it's a name, but Dr. Joe Black has also been listed and defined as the tenant earlier in the lease agreement. So just there in that first sentence, it's outlining that if Dr. Joe Black is not the tenant, then the options to renew would not apply. Essentially, they wouldn't exist for the new tenant. So just be cautious of that. Ideally, the lease is structured under your professional corporation, and then the buyer of that corporation is going to inherit the options to renew. Any such renewal shall be on the landlord's then current standard form lease agreement. Current standard form lease is not defined. I would be worried to know what the landlord's going to do in the future. So let's just make sure that the terms that you've ideally negotiated very well now, because you attended this Wednesday night course on a very riveting topic, that they extend into the future, and that the landlord at every renewal cannot just clean the slate and say, okay, come on, let's go back to the checkerboard here. In no event shall it be less than the rent paid in the last year of the original term. So there's always the element of annual rent increases. We've had a really, really great success in the past year at negotiating caps on those rent increases for more than 3, 4, 5 years because of what COVID did to the market. For the options to renew, let's just be sure that when the option to renew time comes, that you're paying a fair market rate, not that it's going to arbitrarily go up. Because if the market goes down and you all of a sudden have to continue paying more in rent, you're going to feel very slighted. It should be based on the market rent for the renewing tenants in the building. Just my example there kind of outlines why that last sentence is a problem. So the cost of that mistake, having to relocate unexpectedly, could cost a tremendous amount of money, not just in the expenses of building new office space, investing in new leasehold improvements, but also having downtime for new patients. If your options to renew are taken away from you, or you can't exercise them because they're landlord rights, not tenant rights to renew the lease, that could be a problem. And if you have to move, that's a very, very expensive mistake. Having to absorb a significant increase in rent will be very tangible and just boil down to the dollar value of rent increase that you have. And the inability to sell the practice is a problem. Again, for a lot of people who think they have 1 or 2 years left of term, but it's no big deal because the buyer for the business can just set up a lease with the landlord at that point in time, the landlord's going to set up a very increased rental rate because they have built out office space and they've got this new incoming tenant that's going to be signing on to a lease agreement, and they'll try to just increase the rent to them. That's a big problem because now your buyer for the business is getting scared. They're getting very intimidated by the landlord who's increasing the rent because of the fact that they have plumbed out dental office space, and they're trying to tie it to the new market rates. So this is another example. You can see here the highlighted sections of this example option to renew and why it's a problem. And you can see we've redacted a couple, or just that one name there, but I'll just let you read through it. And be very aware in your option to renew provision, you're going to have a deadline to be able to exercise that. So if your lease agreement comes up at the end of 2022, if you have an option to renew the lease beyond the end of next year, most likely it's going to have an option to renew deadline. It could be 6 months before, it could be 9 months before, it could be 12 months before. And if you pass that point in time, if you pass the 6-month deadline, and now all of a sudden you have no right to renew the lease agreement, your leverage in dealing with the landlord just went way, 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 way down. Because what's going to happen at the end of the term? You don't know. The landlord can use that to their advantage and basically put a new agreement in front of you. And the landlords are smart. They know it costs a lot of money to relocate a practice. So just be careful as to knowing when your critical dates are. There's a number of very problematic provisions here, just a few examples, literally a few because there's more beyond this list. To look at a more kind of opportunistic one, the option to renew clause. It's one that for a tenant who has ambitions of growing their floor plate, taking over more square feet in adjacent office space, or potentially buying a building. If you're renting your office space today, if you have an option to renew and there's a unit next to you that becomes available for rent, the landlord has to provide it to you. They don't have to just give it to you, but they have to give you the option to take it over before renting it to anyone else. So if you're in need of a fifth, a sixth, a seventh op, and that space next door just becomes available because the business went out of business, because that neighboring business went out because of COVID, well, great. Now you have your chance to expand your practice. Or if it's a smaller property or whatever size property and you're actually interested in buying the real estate, well, great. The landlord has to, as long as it's in the lease, give you the option to buy the building before they market it to anyone else. And even if you don't have an interest in buying real estate, the buyer for your practice might have that ambition. And now your practice sale value just went up because you have that flexibility outlined in the lease. So don't think that there's no value to these provisions, right? The demolition clause, as an example, from a landlord perspective, if they're trying to repurpose the property, if they're trying to sell that asset to a condo developer, it's going to hold tremendous amount of value because now the landlord has the ability to submit notice to the tenants, kick them all out of the building, and the new buyer, a big builder, real estate developer, whatever, they can demolish the property and put up condos. So there's a lot of potential traps. There's a lot of potential risks in your lease, and I'm going to go through the quick elements as to how we can affect change. So the tenant lease cycle, we call it the Cirrus wheel, is really what we've been using for the past 27 years to affect positive change on behalf of our tenants. So again, the 4 types of practices really that we take on as clients are people who look to lease new office space, someone who is renewing their office lease, expanding their office, or selling their practice. Those 4 different practice types really all have one common denominator, and that's leverage. So for example, the person renewing their office lease agreement, Ideally, you get the conversation started with the landlord up to 24 months before the lease expires. And that's, again, probably because you have an option to renew deadline 6 months, if not a year before that. But you need to start the conversation early, because the landlord realizes if Dr. Joe Black is trying to discuss the lease terms into the next 2 years with me, they must be considering moving, or else why would they be trying to discuss this so far in advance? So it's a very reasonable time to start discussing the upcoming expiry. And with that, the landlord's going to be very motivated to discuss the renewal, right? A dentist is a very, very valuable tenant. Some of the lowest default rates that commercial real estate has to offer, and a large amount of upfront capital invested into buildings that practice owners a lot of the time don't even own. So with that being said, if you get towards the last couple of weeks or days until your lease expires, unfortunately, there's not a lot of leverage, and the negotiations are very difficult, not as smooth and effective if they were up to 2 years before the expiry. So the strategies and tactics for winning the lease negotiations, again, the Cirrus wheel is what we like to refer to when we start the process of, you got to gather your documents, really review the information that's been set in front of you with the landlord, identify your practice goals and objectives, really a vision for your future, try to kind of plan and prepare a goal, a strategy for negotiating the lease, and align it to your practice vision. So you're not tying your life to this lease agreement. You're really making sure that the lease agreement is more or less tied to your life and your practice. Review the office lease for its risks, prepare market research, know what's going on in the market around you. What are the transactions going for down the street or within the same zip code? What are the fair market rent rates? Develop that strategy and outcome development. Review what the economics of the lease are going to look like, all those 7 potential financial components of the lease. Start negotiating the terms. And then at the end of the negotiations, identify, okay, has the landlord tried to change anything? Because there's a whole host of times where we've negotiated a lease for months, and then in the final round, when the landlord sends back the final form, they'll even submit changes in that are, again, just in the landlord's favor, not the tenant's favor, but we're a tenant favorable tenant rep firm. So we just need to be sure that all the provisions in the lease are in the tenant's favor. We've done a lot of great work for clients across, again, the continent. Very proud to say, Dr. Marinas in California, same as the practice owner for the San Francisco Giants, who I was just chatting with a few days ago. She left us a very nice Google review. Feel free to check us out on Google if you're looking for more information on our firm and what it is that we do for clients. The critical dates and risk analysis lease review service is a service that we offer to clients who are looking to have their lease agreements reviewed. So if anyone's interested in a consultation, really just a lease review, more than happy to do so. The cost of this service has very generously been taken care of through the sponsorship with Schein. So there is no cost for the lease review, but typically it's a service that we value at nearly $2,000. What the lease review entails is essentially 3 to 4 hours of review work. So a member of our legal and leasing team would review the lease, identify any potential risks. Our market research team would just prepare a quick analysis on those fair market rent rates and some active stats nearby your area. And then finally, we would host a call with myself or a colleague to really just review, okay, these are the potential pitfalls, this is the market update, and here's a strategy in terms of how to deal with your landlord and how to negotiate with the large institutional real estate investment trust that you might be leasing from, or the smaller property owner that might just have one property to their name. But nonetheless, the lease review service is a very kind of insightful hour-long consultative process where we just connect with the doctor over the phone to review the lease. So if anyone's interested, my contact information will be up just at the end of this presentation. So feel free to email me, or you can email the info at email. And Q&A. So we just went a minute over. I'm looking at the clock here at the bottom of my screen. I feel like I was running out of time. I'll pull up a few questions. I think we've got over a dozen here, but I'll see what we can get through. And we do have a closing poll. So as a part of the exit to the webinar, and I'll again answer some questions, but we just have a closing poll. So for anyone interested in being contacted for a lease review, by all means identify, just click the yes. And then there's a few other kind of identifying questions just for anyone that's got a specific situation and they would like some attention to it. Let's see here. So just referencing now a few of those questions. First, how much do you charge to review your lease? So typically it's nearly $2,000 for anyone on this webinar. This anonymous attendee, there's no cost. So don't, there's no charge for the lease review. Another question was asked, and it's, I own my own building and I'm contemplating selling my associate my practice. I don't think she can get a loan for my practice and my building. How should I set up my lease to protect myself post-sale? Very relevant question. I didn't get time to discuss the value of the lease agreement for a landlord. So what we do for some property owners is create a lease between the practice and the property. It's what we call an arm's length lease. And the value of it is fivefold. Really, it's important because you need to delineate the value between the two assets, right? The practice that you own today and you're hoping to sell, and the property. It's very important because if you're ever looking to evaluate the building, a part of its value will be determined based on the security found in that lease. If you've got a valuable tenant and they have a long term and there's good rates, the building's worth more. It's a good investment play by any potential buyer. So for someone that's looking to buy the practice from you, they're going to need a lease agreement for that financing capability. And the problem that you might be in right now is if they're looking to buy the practice a few weeks from now and you draw a lease agreement up today, well, they're going to feel slighted. They're going to think, where did you get this, this rent information? But if you have a clear track record of rents moving from one company to the other, there's more historical data there. You have a clear track record worth of rents to really prove to the potential buyer of the practice, this is what the building expects for its rent. This is true and factual information. And they, in that situation, would not have a concern with signing the lease agreement or having it assigned to them because it would be performed that way in a practice acquisition. So just setting up that lease, again, a property to practice lease agreement is a very valuable thing. I know for real estate investors that contact us just for some of our market information, they won't even look at a property they won't look at a commercial property unless there's no leases in place, unless they can confirm that there's a fair agreement between landlord and tenant. It wouldn't make sense, right? There's no security, like I mentioned. Another anonymous attendee submitted a question saying, I signed my lease earlier in my career without any help. I wish I knew about your services sooner. My lease is coming up for renewal in the next 8 months. Do I just exercise my option, or how would I make the improvements you spoke about? So you've got 8 months left on your lease. My answer is you don't have 2 years, but you still got 8 months. There's a great deal of leverage. Like I referenced before, you're a dentist. You have some of the lowest default rates ever. You have a tremendous amount of just high covenant associated with just the DDS next to your name. So keep that in mind. And when you're negotiating with the landlord, realize that all of these changes you're looking to effect, they don't take advantage of the building owner. They're really just to try to translate the nuances of dentistry into this agreement. It's like translating just the specificity that is due for your industry in line with the lease agreement. And a lot of landlords, they know how to discuss commercial real estate. They don't know how to discuss dentistry. So a lot of what we do is really just educate the landlord and outline why it's appropriate, how it's not going to take advantage of them. We receive at the end of every year dozens of gift baskets from landlords who've had a very positive experience dealing with us. And we wouldn't have the tenure that we do and the good reputation and Google reviews that we do if we didn't deliver on our advertising. And that's in dealing with the landlords and resulting in just positive results. Another anonymous attendee asked a question, and this is my final answer. As a dentist, if I were to buy a building, would your company advise me when I sell my practice and draw a lease for another dentist? I would, but you should do that before you go to sell your practice. Because again, your buyer is just going to be thinking at the time of sale, why did you just draw this up now? Why wasn't this in place before? There's no historical data. You should have a clear track record worth of rents. And if you do that as a building owner, now at the end of every year, what you've got is proof that you have a very good expense to write off, right? If you've got your rent that you move from one company to the other, now when you're doing your write-offs at the end of every year for tax season, you've got that in place, just identified through the lease agreement. So you should draw that out sooner rather than later, not at the time of practice sale. And with that being said, thank you all for attending. Thank you very much to Henry Schein for tonight's co-hosted event. If there's any questions, the email is up on the screen. You can submit a request. And myself or a colleague would be very happy to get in touch with you. But thank you all. And that's it. Have a good night.
Great. Thanks, Mitch. And again, if anyone does have questions, please feel free to reach out to the Cirrus team via the email or website shown on your screen. As I just posted in the chat, everyone will receive the recording of this webinar sometime in the next week, so keep your eyes out for that. And then if you'd like to attend future Henry Schein webinars, visit henryscheindental.com/webinars for our upcoming schedule. Thanks for attending.
Thank you.